So you were living in a house with your ex-wife and her new husband?
Yes.
Oh, no, I'm just wondering.
I know it's a strange situation, but we actually,
Whoa. Starting off with a classic awkward living situation, imagine living under the same roof as your ex and their new spouse. TV drama reality check. Could you handle that?
Seen that on TV, but okay.
but
Mr. Reyes, in cause number 2025 CR 011977, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
yes,
Did you understand in that cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not there's enough evidence to hold you over for trial? And also that your attorney has certain rights. Your attorney has the right to have the passage of 2 days once they are presented with the information and 10 days to prepare for trial. Did you understand?
yes,
Did you understand by entering this plea, you're giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case?
yes,
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
yes.
All right, off the record, to the clerk. Adriana? Yes, ma'am. I don't have the information in this cause number. Yes, please.
It's just the unofficial signed one,
All right,
unsigned.
and if you can make sure also, Adriana, that you have that.
You did the original one with the paperwork.
All right, we'll need to make sure that we have that before things are done. All right. Did you review the felony information with your attorney? Did you understand it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes.
Counsel, in each of those, are you waiving the reading?
We are, Your Honor.
State in the cause number that is the felony information, are you proceeding on that information as presented?
We are, Your Honor.
And the other cause number, are you proceeding on in the indictment as presented?
No, Your Honor, we will waive count one of the indictment and proceed on count two.
No objections, Your Honor.
All right, in each of the cause numbers, did you review the documents entitled Court Admonishments with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes,
And cause number 2025 CR 07562A. You're charged with possession of a controlled substance, penalty group 2, 4 to 200 grams. I'm sorry, 4 to 400 grams as a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the court were to grant your
Here's a legal lowdown. Deferred adjudication can seem like a sweet deal, but remember, if revoked, the full punishment hits. That's the court keeping its cards close to the chest. Audience, would you risk it or go to trial?
application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
yes,
And the felony information, you are charged with endangering a child through criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
yes,
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases?
yes,
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Reyes, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
I am.
Did you understand by entering into plea bargaining agreements in each of these cause numbers, if you're not a U.S. citizen, you will be deported, not allowed re-entry and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea in the felony information case, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. This will run concurrent with 2025 CR 007562A. And the other cause number, the state is proceeding on count 2. There's a $2,000 fine. The state recommends deferred adjudication, and it will run concurrently with the previous case. Did you understand that to be the plea?
Yes.
Defense?
It is.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, in the felony information case, the state is asking that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, no contact with Skylar Reyes, parenting classes, TAP evaluation, follow all recommendations in the MRT. In the indicted case, the state is asking that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 200 hours of community service restitution, the parenting classes, and moral recognition therapy. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
You said no, Your Honor.
So you understood that.
Okay.
Did you understand that?
Yes.
Then, and cause number 2025 CR 007562A to count 2, how do you plead? Guilty, not guilty, or no contest? In 2025 CR 011977, how do you plead?
No contest.
State any evidence.
For both cases, Your Honor, state offers as evidence, states exhibit 1 of all attachments.
We've had a chance to review both cases, Your Honor, and found no objections.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and cite it in both places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Rick,
Yes, Your Honor.
if you'll just sign this and they'll file stamp it.
Sure.
Thank you.
You're welcome.
All right, in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is taking full responsibility for what occurred in that house and on that evening. Because of that, Your Honor, and because of the fact that he has a clear record, we would ask that to be taken into consideration. The first thing we'd like to address is that the no contact order, although the state asked for it, we did go through a proceeding with the child custody people, and they found that he has had no problems with his child, so we would ask that he had no, at worst, no harmful or injurious contact with his child, so that he can see his child. He is supporting the child and taking care of all of his bills. Your Honor, he is working at this time, and so we would ask that the judge take that in consideration when considering, since the two cases are in together, the amount of community service and hours that he's doing. The TAP evaluations and the other things I've explained to him were things that are probably good that he has to do. He does not have, they've done follicle tests and all kinds of other things, so he did not have any problems with drug use. And so we believe that'll clear him too, and they'll see all that. But we would just ask consideration on the fine, the no contact order, the no harmful or injurious contact, and consideration on the community hours.
All right, state, you want to be heard on the no contact order?
Yes, Your Honor. I wasn't sure if Your Honor would accept me putting in the harmful injurious contact as an option of the court. I will say we had the co-defendants about a month ago, if you recall, Jacob and
Yes.
Kelly. And I reviewed the CPS record associated with all three of them, including this defendant, and this defendant seemed to be the most, and he has a CPS, less culpable for the situation. He passed hair follicle very soon, so his, what they call, believe call family plan was cleared sooner than Jacob and Kelly were the other two co-defendants, so state have not had any objection. This particular defendant had no harmful injurious contact with this.
All right, so were you living with these other people?
And it was,
So how many rooms did this home have?
3 rooms,
All right, and how many bedrooms?
2 at the time that I know of.
So it
that
was-
were being used as bedrooms.
Two were being used as bedrooms?
Yeah, the other room I did not. know what was
All right,
being
so
used.
where were the adults sleeping? Did the adults have a designated bedroom?
They did, but I know a bed frame like broke in the room, as they told me, so they're like living in we're sleeping in like the living room area. So they-
So I'm just wondering, why would you all be growing marijuana in a child's bedroom?
I'm sorry?
Why would there be marijuana grown in a child's bedroom as opposed to an adult bedroom?
From what I was being told, one adult bedroom, it was being grown, and in the other room, I'm not sure what was being done in that room.
No, I mean, it was being grown next to a crib unless the adults are sleeping in cribs.
I understand.
So did you and nobody say, hey, you know what? We're gonna go ahead and grow this marijuana, but it's a bridge too far for me to grow marijuana in the baby's bedroom. Did anybody say that?
No one's talking to me about the marijuana itself being grown.
Just to be clear, Your Honor, the baby was the child of the other two people.
Yeah.
His was 9 years old, sleeping in his room with him.
Hold up marijuana growing in a child's bedroom, that's a hard red flag. The judge is grilling him for a reason child endangerment isn't just paperwork, it's real stakes. Comment below. What would you do if you found yourself in this scenario?
Understand that, but still, somebody is growing, wouldn't you think? I'm trying to figure out what your mindset is.
Right.
Wouldn't the fog clear and you say, you know what, there's just something wrong about people growing marijuana in a bedroom where a baby sleeps?
And
At any point, did somebody say, we have young children here, they shouldn't be around marijuana? And I knew it probably stank. Because we tried a case in this court, and every time they would bring the marijuana out to show to the jury, I ended up getting headaches. It stinks to high heaven. So nobody thought to say, you know what? Let's set up a tent outside if we're going to do this. So at least the children won't be smelling this on a daily. That never occurred to you?
I didn't smell anything, Your Honor, from what Big was telling me, he had, he's like cabinet.
But I mean, you knew marijuana was.
Selective ignorance alert. He claims he didn't know the drugs were being grown, but the judge is clearly questioning credibility. This is where courtroom tension peaks. Watch how one wrong step can shift your whole case.
Being grown. Are you telling me you had no idea marijuana?
I know they were, because they were working at a smoke shop. I didn't know they're actually like farming, as they would say, the marijuana.
So you're saying you had no idea marijuana was being grown?
It was not grown in my room or like in any open areas.
No, that's not my
I did
question.
not know, Your Honor.
So then why are you pleading to endangering a child by having dangerous drugs in a household? Then if you had no idea that there was no marijuana, it sounds like maybe you should go to trial on that case.
I just didn't want to risk going to trial and then doing up to 10 years in prison. I can't do that to my daughter, Your Honor.
Well, no, this is the state jail felony.
2 years, oh, okay.
That's the state jail felony. And then on the other one, they charge you with possession. So are you saying you didn't possess any drugs? There was no care, custody, and control?
On my room or my area, no, Your Honor.
All right, does he want a jury trial? He's saying,
Your Honor, I think without him understanding it, the fact that he lived in the house, the fact that there was stuff in the house, I'm not saying, and I can't say on his behalf that he knew personally. I suspect that he had an idea of what was going on because of the business that his ex-wife and her new husband worked at. But I think because he was always gone, he was making plans to get out of the house. He just wanted to leave, and the problem is the incident occurred that brought everybody into the house. So when he and I talked with him, I asked him the same questions. He basically indicated that I think it was a selective ignorance. He didn't want to know, although, like you say, the smell, the signs that were on the walls and things of that nature, if you looked at the videos, would indicate, and where they worked would indicate there was something going on.
So the other co-defendants, what, is that your ex-wife?
My ex-wife, correct?
So you were living in a house with your ex-wife and her new husband?
Yes.
Oh, no, I'm just wondering.
I know it's a strange situation, but we
I've
actually.
seen that on TV, but okay.
But at start, of course, it was a little rough, but we actually get along, so it was working out okay. And I was actually living in my own apartment before, but with a discussion with my ex-wife and myself that our daughter was having a hard time me being out of the home. So after my lease was up, I actually went back into the house so we could be together until she was a little bit more understanding of what was going on for me to leave again. Yeah,
All right. So do you live in the household now?
it's a different house with them.
No, but you're not living with the ex-wife.
Notice the financial and familial gymnastics. Here, Hayes relying on ex-spouse support while trying to get back on his feet. Legal strategy life, strategy both. It's the human side of the law in action.
Together, so yeah.
So you all are still living together?
It's just been hard financially wise, Your Honor. They actually did help me out by paying my bond. Well, I paid the bond myself and they did reimburse me because they realized the situation they put me in. And I'm just trying to get everything financially wise done so I can actually move out.
So who is your family support other than your ex-wife and her new husband?
All my family got a state here. I have
All
my
right, and
family
what state?
in Florida.
So do you want to transfer back to Florida or no?
Transfer back to Florida?
I mean-
Or is,
Move back to Florida and have your probation transferred to Florida?
I'd like to keep you here, Your Honor.
And are you employed?
Yes,
What do you do?
I'm with the San Antonio River Authority. I'm as a landscape technician.
All right,
You would
That's-
see me off driving around here.
all right. So they said that you had a family-based service plan?
Yes, family plan, correct.
All right, so what did you complete
As
with
far
the
as
family-based service? What did they have you do?
I voluntarily submitted a hair follicle test, that way I could have contact with my daughter immediately upon getting the results. And then I also did see a few more UAs after that with the
Did you
family plan.
complete any parenting classes?
Parenting classes themselves, no. But we did do as far as like visitations from CPS.
I don't know why CPS didn't have them do. Here's the thing, I'm gonna order parenting classes because you need to realize how your actions impact your child. And I don't think people realize that. Because a child can't say, I don't want to live in this situation. I don't want marijuana in my bedroom. Because they're a child, they're not an adult. You understand?
I understand.
All right, in cause number 2025 CR 011977, there's going to be a $1,500 fine. That will be probated. 3 years deferred adjudication. Concurrent with 2025 CR 007562A. Regular reporting by Zoom or in person. Regular random UAs or patch. The patch is more expensive, but it has less time constraints because they will put it on you. You're not allowed to remove it. You'll just report and then they'll remove it and they'll see what the testing says. Field visits 1 time per month until further notice. Proof of employment within 45 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. There's to be no harmful or injurious contact with Skylar Reyes. And there is to be a TAP evaluation. Follow recommendations. Is there anything else that you need from the court in that cause number?
No,
Probation, is there anything else under that cause number? In that case, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. In 2025 CR 007562A, the court is going to sentence you to a $2,000 fine. That will be probated. This will run concurrent with 2025 CR 011977. There's to be proof of employment within 45 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs or the patch. Field visits 1 time per month until further notice. 3 years deferred adjudication. 200 hours of community service restitution. I'm going to order the MRT. Once the MRT is completed, the community service hours will be deemed satisfied. Probation, is there anything else that's needed? All right, and
Boom Judge hits with the life lesson. This isn't just about fines or probation. It's about making decisions that affect a child for years to come. Real talk. Courtroom isn't just law. It's life coaching with high stakes. Retention tip. Those parenting classes not optional theory essential.
I didn't order the TAP evaluation in that cause number since you already have it. Is there anything else you need from the court to be successful?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in
Yes.
that cause number?
Yes.
Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. This is what you have to remember in your life as you go forward. Until your child is an adult, they're dependent on you to make good decisions for them. They can't just say, oh, I'm gonna do something else, because they're dependent upon you. And what I can tell you, even when they become adults, they're still gonna be dependent on you. So you're gonna have to start making better decisions if you truly love your child. You understand? All right, good luck to you, okay? In this court, communication is key. If there's an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with the court, okay?
Thank you, Your Honor.
All right, you're welcome. Good luck to you.
Please.
Yes, he'll need to talk to probation.